Senate Maritime and Admiralty Zones Committee hearing is hereby resumed. Committee Secretary, can you acknowledge the guests present physically and virtually?
Good morning, Mr. Chairman. Good morning, distinguished guests. For today's hearing, Mr. Chairman, we have representing the DFA, Secretary Manalo, we have Yusek Jesus S. Domingo. With him is Director Andrea Lecano and Attorney Lou Brian Macabodbod. We also have physically present, Mr. Chairman, is Solicitor General Minardo Guevara. Morning, sir. With him is Attorney Jane Yu, Senior State Solicitor. For the National Mapping and Resource Information Authority, we have Deputy Administrator Efren Carandang. From the National Intelligence Coordinating Agency, we have Director Maria Luisa F. de Guzman. With her is Mr. Mauro Tongco. From the National Security Council, we have Deputy Director General Marlo Guloy. From the Department of Justice, we have Senior State Counsel Attorney Freddy Ganchoon. We also have former Chief of the Bureau of Fisheries and Aquatic Resources, Ms. Sandra R. Arcamo. Mr. Chairman, we have virtually attending Dr. Stuart Kay from the Australian National Center on Ocean Resources and Security. Also virtually attending is Professor Robert Charles Beckman, Faculty of Law, National University of Singapore. That is all, Your Honor. Thank you.
Thank you. May we know from our virtually present resource persons the time difference? Professor Beckman, are you in Australia or in London? Because we're considerate of the time difference and your convenience while attending this hearing virtually. Where are you now, sir? Can you unmute? Technical, did we lose him? We can still see him. What about Professor Stewart? Are you in Australia or?
Thank you, Your Honour. I'm in Australia and I think I'm 2 hours ahead of you.
2 hours ahead. Not so bad. What about Professor Beckman? You're in. We cannot hear you. Technical, can you unmute? Can you speak, sir? Naririnig ba tayo? Can you hear us? Can you make a thumbs up sign? Can you make a thumbs up sign if you can hear me? Hindi siguro tayo narinig. We've lost audio contact. I will try to connect later. Good afternoon again. I think we have expect the presence of former Supreme Court Justice Hardelesa. Is he here? He's on his way. Coming from the first hearing, we required several agencies and groups to provide us with position papers, notably from the Department of Foreign Affairs, which I just received a minute ago. And the other one came from the University of the Philippines Maritime Institute. Is the UP Maritime Institute present? Thank you, sir. I think I have in my possession the paper which you submitted yesterday. So we asked the organizations present to provide us with their positions relative to the two items raised by Professor Stuart Kay. And to refresh the memory of those who participated during the first hearing, can you rephrase again, Professor, including the chair, the positions? One, I can recall about reciprocity, why there is a danger if you gave us some words of caution if we place the word reciprocity in the proposed law. And then the other one is, can you do that for us? Can you guide this committee again, Professor? You have the
Certainly,
floor.
Your Honour. Yes, I did express some concern about reciprocity because of the difficulty in making that effective, particularly where foreign vessels may be flagged in places that are different to beneficial ownership, and the burden on particularly the DFA to be aware of the various positions of a number of states. So I caution that it would be a lot of work to undertake that. The second area was whether some consideration should be given to a consideration of marine scientific research. The Philippines has the ability under the United Nations Convention on the Law of the Sea to put in place an approval mechanism, and with that conditions upon foreign states undertaking research in its exclusive economic zone.
Before you continue, Professor, we recognize the arrival and presence of an esteemed member of this committee, Senator Sherwin Gatchalian. Please proceed, Professor.
Yes, so the benefits of doing this would be to ensure that the Philippines would have excellent control over what research might be undertaken in its exclusive economic zone, to make use of that to build capacity for researchers and scientists, as well as being able to refuse permission explicitly in the event that a request was made that was not perceived to be in the interest of the Philippines. I think that summarises the 2 points that I made on the last occasion, sir.
I was talking to Senator Gatchalian. Reciprocity clause is the first, and then the second one is?
Marine scientific research.
Okay. That's the question which those are the two questions where we asked the other agencies present during the first hearing to respond to. And I have here a position paper coming from the University of the Philippines, but the committee is aware of several maritime zone laws, Professor. I have here in my presence Taiwan's maritime zone law, and Article 7 therein would have a reciprocity clause on innocent passage, and it would appear that several other countries would have the same feature, a reciprocity clause. I reckon that this has been a practice, and the University of the Philippines Maritime Institute provided us with a modified reciprocity clause. Can you explain that, giving the President the power to exercise flexibility, etc., etc.? Who was the one who submitted this? Professor Attorney Silva? Can you elaborate this further to guide the committee? And perhaps Professor Stuart Kay can have his own response. Go ahead.
Good morning, Your Honors. This is to elaborate on the position paper submitted by and signed by Director J.L. Batong Bakal of the University of the Philippines Law Center, Institute for Maritime Affairs and Law of the Sea. It was noted in the paper that while the idea of reciprocity is primarily associated with comity, there's an underlying expectation, of course, under international law, such as, for example, the regime of countermeasures that would allow certain temporary non-performance, for example, of international obligation towards delictual states. But as noted by Dr. Batong Bakal, the concerns raised by Dr. Stuart Kay are actually very well taken. And so Dr. Batong Bakal proposed a modified provision on the reciprocity clause that would modify it by stating that, if I may quote, the modification would be subject to full compliance with UNCLOS and its dispute settlement provisions. The President of the Philippines is authorized to institute countermeasures or other appropriate steps as may be recommended by the Department of Foreign Affairs. So basically, this this does not impose a basic an obligation not to afford rights to countries who do not perform, for example, their flag state obligations, but rather leaves it to the discretion of the executive branch as the architect of foreign policy, with a recommendation and subject to the expertise recommendation of the Department of Foreign Affairs. The UP Law Center believes that this modified provision would balance the desire of the committee and the authors of the bills to ensure respect for Philippine law, but at the same time taking into account the concerns raised by Dr. K and also that may be raised by our partners and friends in the international community. Thank you.
Thank you. Before I ask the comment or response of Dr. K, I just browsed through the paper given to me by the Department of Foreign Affairs, and it appears that you can confirm this, Undersecretary Domingo, that the Department of Foreign Affairs, and I'm quoting the paper coming from DFA, quote unquote, the department agrees with the comment of Dr. K that the inclusion of a reciprocity provision is not feasible from a practical point of view, as the department or law enforcement agencies will be expected to know in advance the internal regulations of all other flag states in determining whether or not it allows the same privileges for Philippine flag vessels. The department likewise acknowledges the present wording the provision might be construed as inconsistent with UNCLOS as regards rights of foreign vessels and aircraft, as it conditions the exercise of said rights on reciprocity and mutual respect and not as a standalone right. So it would appear that the DFA is agreeing with Professor Stuart K. But with the indulgence of Professor K, I'd like to have the DFA explain this. Undersecretary Domingo, you have the floor.
Okay. Thank you, Your Honor. Senator Tolentino, Senator Gatchalian, dear members of the Special Senate Committee on Maritime Admiralty Zones. First, I'd like to extend Secretary Enrique Manalo's appreciation to the Senate for spearheading the maritime zones bills in the Senate, but unfortunately he's caught in the House hearing on our budget. So thank you very much, Mr. Chairman, Mr. Senator, that yes, we are in overall agreement with Dr. K with respect to his position, his view on the reciprocity and mutual respect positions. And yes, sir, as stated in our policy paper, that again, it is not practical. Number two, it may not, it's inconsistent with UNCLOS. And we feel that already in the executive branch, the president already has the inherent power to formulate rules and regulations to implement the rights and obligations of the Philippines as a coastal state within its own maritime zones in accordance for UNCLOS. So we feel that any specific language would just constrain and perhaps not be necessary and just cause more complications. So again, thank you, Dr. K, for the position, and so that is how the DFA views it. Thank you, sir.
Thank you, Undersecretary Domingo. Dr. K, any response? Any additional statement? Having heard the University of the Philippines Maritime Institute.
Look, Your Honour, I have been a friend and colleague of Dr. Batong Bakal for many, many years. And certainly I'm happy to
Testing 1, 2, 3. Can you hear me?
Who is
I
Dr.
think that might be
Dr.
Professor Beckman is online.
Yes, Dr. Beckman, we can now hear you, but we'll allow first Dr. K to finish his statement.
Surely. Thank you, Your Honour. Look, as I was saying, I've known Dr. Batong Bakal as a friend and colleague for many, many years, and would defer to him with his knowledge of the law of the Philippines. Certainly, the modification that he suggests deals with, to some extent, the practicalities that the DFA in their submission have referred to. It doesn't, however, deal with the issues directly with the consistency with the law of the sea convention. But I would note that it would be, I imagine, an unusual thing for the president to do, and therefore would be something that would be considered at the very highest levels of government. And in those circumstances, the suggestion by Dr. Batong Bakal doesn't strike me as unreasonable. Otherwise, I'm very happy to concur with the DFA's response and gratified that they see things in a similar fashion.
Okay, there's another paragraph here coming from the Department of Foreign Affairs, and I quote, "The department proposes that the language be deleted." In toto, I suppose. Yusek Domingo?
Yeah, yes, sir.
So it will just be redundant?
Yes, sir. And for the reasons stated, we feel that it just should be left out. Thank you, sir.
May we get the reaction from the Solicitor General? If you have a copy, or are you in sync with what's been discussed?
Good afternoon,
Yes.
Senator Tolentino, Senator Gatchalian. I wasn't here during the first hearing because of another official appointment. We have prepared a position paper in general on the Senate, proposed Senate bills, as well as the one coming from the House of Representatives. But on these particular issues that were taken up during the first hearing, we are unable to come up with a specific comment on these two specific issues. But so we will tackle, from our point of view, our position on these two issues if you'll give us ample time to prepare for it. But offhand, Mr. Chairman, the matter about reciprocity and mutual respect as a general proposition seems to be all right, seems to be acceptable as a matter of general proposition. I think that is fair from all sides, from all parties concerned. But there may be some possible provisions of international law that we have to look into to make sure that the inclusion of any such provision will not be in conflict with UNCLOS or any other international convention. But as a matter of general proposition, I think it is fair to have something like that in our maritime zones law.
The basic foundation of Professor K's disagreement with this is because we're dealing with a multilateral convention, and quoting him, caution against the use of doctrine of reciprocity in a multilateral convention can be quite complicated because it would involve the realistic or unrealistic inspection of vessels, vessels coming from the high seas, not knowing fully well whether they are part of a treaty that would require mutual reciprocal treatment by the Philippine government. So I think, Professor, your main concern is about the practicality of this, whether this can be achieved inspecting vessels, etc., etc. Is that right, Professor K?
It's certainly a very substantial concern, Your Honour.
The applicability. But we'll give the Solicitor General, the Office of the Solicitor General, the time to produce their own position paper. During the last hearing as well, we asked the Department of Foreign Affairs to provide this committee, unless Senator Gatchalian, you have to provide this committee with existing maritime zone laws in other jurisdictions, particularly the ASEAN and some claimants within the West Philippine Sea. Is the Department of Foreign Affairs ready to apprise the committee with the said concern? Are there other maritime? And then we will now zero in on the question of overlap. Are there overlapping maritime zone claims as we speak? And as per UNCLOS, what should be the basis for the delimitation of overlapping maritime boundaries? This would be a continuing concern. Even if we produce a maritime zone law, we might overlap with that of Vietnam or Malaysia or Brunei Darussalam. What has been the practice? We'll give you a longer period here, unless Professor Beckman, you want to jump in? Can you hear us? We
I think
cannot.
at this point.
You can hear us, sir?
Yes, I can hear.
Where are you right now, Professor?
I'm in Singapore at my home.
So time difference probably would be
No
zero.
difference, I think.
No,
Maybe
We-
1
we-
hour. I'm not sure.
we hope we can provide you lunch where you are right now, but unfortunately, we're not in contact with the Philippine embassy there. So, can you provide us a perspective on the issue at hand, the reciprocity clause, before we ask the Department of Foreign Affairs to make their own presentation?
Well,
Is there a need for this?
I was caught a little bit unawares on this because I haven't looked at any of the documents, and I was just invited this morning to attend the meeting. So I would probably, I know both Jay Botangkakal and Stuart K very well. I would support their positions on this, even if they may be in slightly different views. I really have not had time to study the issue, and I'd rather not just wing it.
We will ask the Secretariat to provide you a copy of the bills under review through your email, Professor. So
Okay,
that just
thank you.
just the issue of reciprocity. We now ask the Department of Foreign Affairs to apprise this committee as to the overlapping claims of other ASEAN or claimant states within the South China Sea, West Philippine Sea. Who will speak? Do you have a PowerPoint presentation?
Thank you, Your Honor. As instructed, the DFA had prepared a summary and extracted provisions of the relevant laws of our neighbors in ASEAN.
But before you proceed, I was just informed that the Department of Justice is ready to comment on the points raised by Dr. K. I'm sorry, Yusek Domingo. Is the Department of Justice represented here? Kayo po.
Good
Sorry.
afternoon, Mr. Chair.
Introduce yourself.
Mr. Chair, my name is Fretty Ganchun. I'm a senior state counsel at the Department of Justice, Mr. Chair, and I'm authorized to attend this meeting.
Yes, what about the reciprocity provision?
Yes, Mr. Chair, we have prepared a position paper, and apologies, it's still
Don't have it here
undergoing
with me.
its internal review process, but we target to release it next week, Mr. Chair. And we have revised it actually to take into consideration the comments that were made during our last meeting, Mr. Chair. So with respect to the comment of Professor K, he actually made 3 comments. No? His first comment is with respect to the maritime zones of territories outside the archipelagic baselines of the Philippines. And his second comment is with respect to marine scientific research. And lastly, on reciprocity clause in our bills, Mr. Chair. So with respect to reciprocity, the
Any
DOJ
advanced
actually-
information coming from your end as you craft your position paper?
Yes, Mr. Chair. I've listened to DFA and IMLOS as well as the Solgen and Professor Beckman, of course. And actually, the DOJ agrees with all of those statements. This principle of reciprocity exists in the international plane because of the way international law operates. If you are offended by the act of another state, because of the absence of compulsory jurisdiction or an international police force in the international plane, you're actually authorized as a sovereign state to take action to counteract the offending state. So that's based on the principle of reciprocity, and it is also covered by the doctrine of countermeasures that Professor Attorney Neil has talked about. So I took note, the DOJ took note, Mr. Chair, that what Professor Beckman actually says is not about the illegality of the provision, but the difficulty of making that particular provision operational. So hindi po siya illegality, it's about making it operational. And in the position paper of the Department of Justice, I can say that we have modified also this particular provision, Mr. Chair. And we feel that the issue is not really about illegality, but it's about wisdom. Do we need to place this particular provision in our bill? Because even without this provision, Mr. Chair, the President can take countermeasures against the offending state. So we leave it for the Department of Justice. It's not an issue of illegality, and this is clear from the comment of Professor Beckman that it's about the difficulty of making this particular provision
Professor
operative.
K, you mean, Professor K?
Professor K. So it's the difficulty of making this provision operative. So it's not a question of illegality. If we do,
Practicality.
it's practicality and the wisdom, Mr. Chair, on whether or not we should put this particular provision in our bill. So the DOJ has explained it in this position paper, and we have modified also the language if the Senate decides to, based on its wisdom, to also include this particular provision in the bill. Thank you so much, Mr. Chair.
Thank you. Senator Gatchalian is recognized.
Chair, just to continue the discussion with Attorney Fretti, I was reading this provision, and it's written here that vessels and aircraft of foreign states do not abide by or are inconsistent with the UNCLOS international law. Who determines who is abiding and not abiding, and who determines who's consistent and inconsistent in the context of reciprocity?
Thank you, Mr. Chair. Thank you for the question of His Honor Sen Gatchalian. If we connect this to the West Philippine Sea, for example, if there's a state there that violates our sovereign rights, Mr. Chair, who complains? We file diplomatic protests, isn't it, Mr. Chair? And of course, before we file diplomatic protests, we need to determine the flag state of that vessel. So we know actually who is offending us by first determining the flag state of that vessel. It's actually the executive branch, because it's the executive branch who enforces the law. And if somebody violates the law, the executive branch would, of course, complain against the offending state, Mr. Chair. So the taking of countermeasures, for example, belongs to the foreign policy power of the president, actually, Mr. Chair. Thank you so much.
Yes, if you read the news, there's so many accusations going around. Of course, China is accusing us violating UNCLOS. We're accusing them violating UNCLOS. There's so many accusations. So who now becomes in this context of reciprocity, who now becomes the arbiter of who violated what and who's inconsistent, if there's such a thing? Or are we just going to take a stand and say, you violated it, therefore we can enforce, we can implement countermeasures as we deem fit?
Thank you, Mr. Chair. With respect to that question, how would you know who is violating what? All right. This is where the concept of rule of law comes in. Because there is the Constitution, for example, locally you have the Constitution. If somebody violates the Constitution, we say that that person is acting illegally or unconstitutionally. The Constitution for the oceans is the UNCLOS. And if somebody is violating the Constitution of the oceans, we see right away. And with respect to our rights in the West Philippine Sea, this has been affirmed already by the Arbitral Tribunal, which only actually applied the provisions of UNCLOS. So when you say who is right, who is wrong, we have the Constitution. And the Constitution for the oceans is the United Nations Convention on the Law of the Sea. Thank you, Mr. Chair.
Thank you, Attorney. We now give the floor to the Department of Foreign Affairs. My pending question here.
Thank you, Your Honor. Well, at this point, I beg the indulgence of the Chair. What we're prepared to present to the committee is our general observations, because we had submitted, to Your Honor, a detailed matrix with the relevant provisions from the laws of our neighbors, including Taiwan. We can, at this point, I would ask Director Attorney Lecano to give an overall view. But
It's because I could barely read your, I think this is the smallest font.
yes, sir. We apologize for that. But we feel that if we may, because much of what is indicated is, and our analysis is sensitive, if we could be allowed to present to you at another occasion the detail
Sensitivity of what?
with our analysis of the laws of
You
the-
you can skip the analysis, but the maps,
Okay.
the overlapping boundaries, this can be easily retrieved from the various websites available.
Okay,
So, but if any analysis would be coming from your end and you think that would be quite sensitive, you can forgo that. But the maps that perhaps visually would show the overlapping.
Your Honor, what we could do
Claims.
is, thank you, Your Honor. We could share with you our, the comparison of the text of the various laws. But with respect to maps, we just at this point have a general map, and we would kindly defer to Namria for if there's more detailed maps.
To the maps of other countries, is Namria technically capable of determining the jurisdictions or boundaries of other countries as well? Is it
Well-
with part of your job description?
Or at least, sir, with respect to our maritime domain and that of our immediate neighbors. But if we may, could we could just present our presentation. We could present a summary of the laws of our neighbors.
Yeah. Yes, please.
Okay. Thank you. So, Director Lecano, please.
Thank you very much, Yusek. Good afternoon, Honorable Senator Francis Tolentino and Honorable Senator Win Gatchalian, and to everybody here. I will be presenting on the maritime zones laws of ASEAN countries, plus China and Taiwan. So if I may have the slides, please.
Technical, can you assist? Later, perhaps the DFA, you can assist this committee by giving us a summary of the 2012 case, Nicaragua versus Colombia, International Court of Justice, so that we can be guided as well.
Thank you very much, Your Honor. As for now, I am clear to talk about the maritime zones law of the different claimant states. So next slide, please. Okay, so we have looked at the next slide, please. Thank you. So we've looked at the claimant states. So we have here Brunei, China, but I'm going to, don't go to the next slide, but I'm going to talk about Brunei, China, Malaysia, the Philippines, of course, Taiwan, Vietnam, Cambodia, Indonesia, Laos, Myanmar, Singapore, Thailand, that's the AMS states. And we also have a bit on Timor-Leste. So on Brunei, the Brunei government has, Brunei as a state has the Territorial Waters Act of 1982. This is pre-UNCLOS because UNCLOS entered into force in 1994. For China, they have the declaration of...
Incidentally, you can have your lunch while we're listening.
Okay, thank you for that, Your Honor. So for China, the Republic of China has laws on the territorial sea, on the baselines of the territorial sea, it's in 1996. And then on the contiguous zone, they revised that on the territorial sea and contiguous zone in 1998. And then the EEZ and the continental shelf of the Republic of China in 1998. And they also have a survey and mapping law of PRC, which is just an order, executive, but for their purposes, it's a law. For Malaysia, they have a Continental Shelf Act in 1966. This predates UNCLOS. And they have an emergency or essential powers ordinance. This declares the 12 nautical mile territorial sea, which is actually customary international law at the time. And then EEZ Act, dated 1984. This is concerning their EEZ. And this also predates...
I'd like to recognize the arrival of Justice Sardilesa. Sir, Justice, please be seated. Can you assist, Comsec? Go ahead, DFA.
Thank you very much, Your Honor. For the Philippines, of course, we have PD 1599 establishing the EEZ of the Philippines and RA 9522, which is the Philippine Baselines Law. For Taiwan, there is a law on the territorial and contiguous zone. This is dated 1998. And they also have a law on their exclusive economic zone and the continental shelf This is in January 2021, quite recent. In Vietnam, there is the law of the sea in Vietnam, which is actually the maritime zones law. We looked at this because this is our neighbor and has relatively the same issues as ours. Cambodia, they have a declaration on their extent of their
Technical, can you match the, oh, nawala. Oh. Right, go ahead.
Thank you, Your Honor. We are on slide 5, ma'am. Okay. For Cambodia, they have a law on their maritime zones that established a 12 nautical mile territorial sea, and they claimed another 12 nautical mile contiguous zone from the baselines. That's also per UNCLOS, but they are not a member of UNCLOS, I must say. I must note that Cambodia is the only ASEAN member state that is not an UNCLOS state party. For Indonesia, the Indonesians have an exclusive economic zone declaration. That's Act number 5 of 1983. But we have no available copy online of this particular one, Your Honor. By the way, the laws that we're discussing right now, we got this from the UN DOA laws, which is the repository of the maritime laws as submitted by states parties. So for the Indonesian waters, they also declare their territorial sea and archipelagic waters. That's by a law in 1996, after UNCLOS already. And they have government regulation number 61 of 1998. This is the archipelagic baselines of Indonesia in the Natuna Sea. They also have an ASL law, archipelagic sea lanes law, but actually this is more of a presidential regulation that they sent, and that's the one that was it's a partial designation of the archipelagic sea lanes. For Laos, there's none, of course, it's landlocked. For Myanmar, there is a law on territorial sea and maritime zones law. It's in 1997, predating UNCLOS. And there's a law on territorial sea and maritime zones law in 2008. For Singapore, they've been relying on the UK Territorial Waters Jurisdiction Act of 1878 until I think 2008. They have the Singapore Maritime Zones law, but we do not have, unfortunately, we weren't able to get a copy yet of this one. For Thailand, there's a proclamation on the breadth of territorial waters, exclusive economic zone, and for the laws from Thailand, the territorial waters exclusive economic zone laws are this predate UNCLOS as well as their baseline and internal waters law. Yes, ma'am. Yes, sir. Yes, Your Honor.
From the DFA, would there be any possible conflict if we passed a maritime zone law when other countries similarly situated with claiming the same area would come into conflict or overlap with what we are about to pass? They were first to enact a law. Would there be a greater conflict, even if they're ASEAN states also?
If I may answer, Your Honor, as long as the law that is passed is compliant with UNCLOS and has appropriate provisions in maritime delimitation in case of overlap, then I think it can be, it's okay, sir, because that gives us a basis for engaging into negotiations on maritime delimitation with other states that have adjacent or waters that have overlaps between the
So
two
in effect,
countries.
you're saying that in this proposed law, the proposed bills, Section 74 of UNCLOS should have to be specified.
It depends on the wisdom.
Or deals with overlapping.
Thank you, Your Honor. It depends on the wisdom of the legislature on whether or not you would opt to actually adopt the actual language in the actual Article 74, or if you would craft it in your own language. But if we may caution, sir, that it has to be very specific and precise so that we don't we don't unduly go beyond what is within the UNCLOS, so that we're consistent, sir. What we are after here is, if I may, consistency of our domestic law with the treaty, sir. Thank you, po.
You may proceed, ma'am.
Thank you, sir. If I may go through the rundown again. For Thailand, they have quite a bit of a number of laws on maritime issues, specifically the maritime zones. They have an EEZ proclamation in 1988 from February and July. And then, of course, there was an announcement from the Office of the Prime Minister on the baselines and internal waters. So, it really depends, sir, on the country. So I note it really depends on the country. Some of them are laws, some of them are executive proclamations. For the right of innocent passage in territorial seas, there was also a statement from the Ministry of Foreign Affairs, but we didn't find an actual law. So sometimes it's just statements, sir, that actually establishes a particular zone in some countries. And there's a royal proclamation establishing the contiguous zone of Thailand in 1995. Again, I note that this predates UNCLOS. For Timor-Leste, there's a maritime borders of the territory law. It declared and provided for an UNCLOS compliant breadth of the maritime zones and provided for sovereignty, sovereign rights, and jurisdiction. So that's usually also what we use as our formulation for our maritime assertion of our rights and obligations over our maritime zones. So unfortunately, the next few slides have, as the Honorable Senator noted, the Honorable Chair noted, quite very small fonts. So we apologize for that, but there is no other way of showing the comparison between the laws of each of the countries that are specified here. So we.
Yeah, it's bigger now.
Thank you very much, Your Honor. So here we have Malaysia, Vietnam, Taiwan, and the Philippines. These are the ones that we noted. We tried to compare the provisions on particular maritime zones.
What you're telling us, ma'am, Malaysia, Vietnam, Taiwan, and Philippines, all UNCLOS parties would have potential overlaps.
Sir, I note, sir, Taiwan is not an UNCLOS state party, yes.
Sorry. So all of them, Malaysia, Vietnam, Philippines, if we pass this measure, would have potential overlaps and would trigger the application of Article 74 of UNCLOS.
Well, yes, sir. That might be the necessary consequence depending on the actual language, the final language of the law that is passed. But that might be an added impetus for maritime delimitation.
So we will not go into specifics, but would it be in terms of square kilometers of maritime space, which would be bigger in terms of overlap? Is it Vietnam or is it Malaysia?
Apologies, sir, but on the matters concerning maritime, I would have.
Is it secret?
I would have.
You're not nodding your head. What is secret about this? We're supposed to pass a law. We're supposed to pass a law, and we're crafting a law in a transparent manner, so that we can have all the fine features of this. So there's nothing secret. Alam nyo, kayo task force on West Philippine Sea. Akala nyo kayo lang yung may monopoly nung pwedeng sabihin dito. Hindi tayo matatapos dito kung hindi nyo papayagang sabihin. We can send you out of this room if you want. There's nothing secret about this. What we're doing is for the Filipino people. There's nothing secret. Walang sekreto rito. Ano ba yung pinagbabawal dito? Ginagawa nga natin yung tamang batas. You look from the perspective of confidentiality and it as if something that leaks out would be used against us. Pero ito nasa labas naman to eh. May mapa sila. Mapa ng Malaysia, mapa ng Vietnam, o mapa ng Taiwan. Pagbabanggain lang yun eh. Hindi natin to magagawa yung batas na to kung kayo ay nag-aala James Bond. Di ba? Sherlock Holmes. Hindi. Kailangan natin tapusin ito eh. Hindi kaya to na pending na matagal. Because under the cloak of secrecy, it is as if there is no whole of government approach. We're doing this holistically. So, Attorney Jane Yu, I don't know the reason for your, ganyan din si Namria. Gusto ni Namria, executive session. Bakit magkaka-executive session dito? Yung batas ng Vietnam, kahit i-retrieve mo yan sa mapa ngayon, sa website, lalabas yan. Yung batas ng Malaysia, nandun. Are we violating something? Wala ako nakikita. Inaaway ba natin ang Malaysia, Vietnam? We're trying to craft something that would perhaps in the end produce a proper delimitation agreement with the overlapping jurisdictions. And this would be for the benefit of all the claimant states. Kung hindi, wag na tayo mag-hearing dito. Di ba? Natakot na tayo do, hearing pa lang ito, natakot na tayo. Wala na mangyayari. I just came from the budget hearing of Department of National Defense. Ngayon lang, katatapos lang, kaya tinapat natin 12:00 ito. So a lot of things are going on. So there's nothing secret. Senior State Solicitor Jane Yu, there's nothing secret about this. Mapa to eh. Any 17-year-old guy can retrieve a map from the website of Malaysia, Vietnam, or Taiwan. Ang ginagawa natin para sa Pilipinas. Anything to say?
Humihingi po ako ng paumanhin, Ginoong Senador, Mr. Chair. Hindi po ito dahil sa tayo po ay nagtatago, ngunit ang ating pananaw po lamang ay maaari pong may mga sensitipong bagay na
Like for instance, what?
halimbawa po kung ang mga bansang iyon ay sila rin ay nagagawa ng kanilang delimitation ngayon at yun po ay magiging subject ng ating diplomatic negotiations. Yun lamang po.
But delimitation is a treaty, it's an agreement, it's a bilateral process. So hindi yung delimitation. Delimitation under Article 74, Article 74 is a process. Mag-uusap, ito yung amin, hanggang dito, we apply the equidistant principle. So there's nothing wrong. It's not a hostile negotiation. So ang ginagawa na, before we go into that, ang atin dito, bago natin balangkasin ito, para mabalangkas natin, if we would like to do this correctly, we have to know at the very start, sino yung naka-overlap na sa atin? Hanggang saan yun? Hanggang saan yung easy nila? Hanggang saan yung continental shelf na nila? Diba? That's coming from the baseline law of the Philippines. So hanggang saan naman tayo makakapunta? If we will be hesitant, we will not produce anything. If we will be too diplomatically cautious, we will not arrive but the job of the Senate is to produce the legislation here. Our job here is not to be diplomatically hesitant. It's out there in the open. Hanggang sa alam naman natin 200 nautical miles. So any app can produce a figure or a map where that 200 nautical mile is. There's nothing wrong with that. Is there a ban? Kung ayaw nyo, you're not part of this meeting. We will produce our own.
We submit, Your Honors. Thank you.
DFA, can you say something? Saan ba nag-over? There's nothing wrong with this. Hindi natin sila inaaway.
Sir, if I may, sir, may I, with regard to the particular issue on delimitation, aside from the fact that it's quite a technical issue and it's subject to negotiations,
Before, even if we can produce our own maritime zone, even if we don't negotiate pursuant to Article 74. The implications after that law is passed would be what would be encompassed by Article 74. The implications, the consequences.
we are very well aware, sir, of the implications of maritime delimitation talks, and that's
We don't negotiate first before we produce our maritime zone law. Is that, on the other hand, we should produce the law. And thereafter, because they have produced their own laws. Were we consulted when they produced their maritime zone laws? Palagay ko hindi. Palagay ko hindi. This predates UNCLOS. 1966. The other one is I've seen 1986 kanina. So we were not consulted when they produced their own maritime zone laws. The general framework here is UNCLOS. We're operating under the framework of UNCLOS. So ang gusto nyo ngayon, mag-negotiate muna. Excuse me po, dito kami tatama. Pwede bang ganito yung gawin namin batas? Of course, hindi papayag yun. Magtatagal yun. Magtatagal pa yung usapin. Diba? So how can we lay claim officially under UNCLOS that this is the extent and breadth of our territorial domain if we're hesitant? DFA.
Sir, if I may, we can assure that the DFA is not hesitant in protecting the rights and the rights of the Philippines as a coastal state under UNCLOS. I think
Sir?
the goal of the exercise and the goal of at least the Department of Foreign Affairs.
This is not an exercise. It's not an academic exercise.
Yes, of course,
It's
sir. But
laying claim to what is ours.
yes, sir. Of course, I agree with you in total agreement. But the goal is really to put our archipelagic house in order under international law. The maritime zones are already established under UNCLOS, but what we seek to do is to put our archipelagic house in order. That's why we have our own. That's why we're pushing for the passage of the maritime zones bills. On the matter of maritime delimitation, I'm afraid I am not cleared yet to discuss this but we do note that this is one of the things that is being done by the government when it comes to our neighboring countries where we have maritime areas that are overlapping. So this has been done, sir. This is being done based, of course, on what is existing, what laws are existing. But what we are saying, sir,
In
is
effect, you're not in a position to divulge anything. Kung ganyan kayo cooperative, we'll no longer invite you here. We will no longer invite you here.
we submit, Your Honor, but we are always ready
Take
and
note of that, Secretary.
we are ready, sir, and able to always assist the Honorable
You're
Senator.
not assisting us. You're providing hindrances and blockades. I'll raise that during your budget hearing. Definitely, it will be an issue of concern. Wala kayong natulong dito kung yung papakita lang yung kung saan yung mapa. The same is true with Namria. Yeah, parang takot na kayo, mapa lang, takot kayo na hindi ko naman kayo pinapupunta sa ayungin. Yusek Domingo.
If I may, Judge, I wish to apologize.
Register foreign resource persons. We're just having a play of words here while missing lunch.
Okay. Yes, our apologies, Your Honor. So DFA is of course, completely at the disposal of the legislative branch to help pursue the enactment and the formulation enactment as well. So we just again our general work entails negotiations with other states. But on this particular, the crafting of the laws, the paramount importance, of course, here is the passages law. So if we can go, we will be happy to assist fully the committee on the specific provisions. And
How can you negotiate without yet that piece of legislation? And how can we produce a workable piece of legislation if you are hesitant to participate, even if you're here physically?
Well, Your Honor, yes, we are here to fully assist the special committee in the formulation of the law. So absolutely, so we agree that the paramount importance of passing our own law. So we are at your disposal, Your Honor.
The number one precept here is don't mind the other domestic laws of other jurisdictions. We have an international framework, the UNCLOS, and we're crafting our own law. So you have to realize that. I think I will have to recognize Justice Hardelesa. Justice, I understand you're in you're supposed to attend another meeting. Just two questions coming from this committee with the indulgence of Senator Gatchalian. Why is it important, sir? Justice, Your Honor, why is it important to enact a maritime zone law so far as the Philippines is concerned? Would it solidify our claims as validated by the 2016 arbitral ruling? Number two, would it produce conflicts seemingly coming from the hesitancy of some resource persons here? Would that produce more conflict, or would it fortify the already validated claims of the Philippines? Justice Ardeles, I have the floor.
Good afternoon, Senator Tolentino, and good afternoon, Senator Gatchalian. Thank you for inviting me. I'm a private citizen. So to the first question, sir, I've been following the proceedings of your committee, and I listened intently at the first proceedings through TV. And you will remember, sir, that you, Senator Tolentino, you specifically noted that when we fought in the 2013 court proceedings, you noted at this committee hearing last time that China specifically pointed out as an argument that we did not have we belatedly, sir, I think that was the point. The country belatedly adopted our baselines law. That was a big point for China. And we had no response to it because it was true that we in fact enacted our baselines law, I think, very late. So to me, sir, to your question, we should have in fact had this baselines law yesterday. Now, to your second point, will it help? Of course, sir, it will help. And speaking as a private citizen, fortunately, I don't have to report to any secretary. I say, let the Filipino people learn everything here. Because but your question, it seems to be only, should we state in our law where our baselines lie? I think, sir, yes. There should be no secret about it. So, but that's a private citizen's opinion, sir.
Justice, what's the importance of having a maritime zone law now?
Well, sir, the importance of a maritime zone law now is that, as I said, at the last litigation we had against China, they pointed out specifically, so we should learn from that lesson. Because I now am advocating that the OSG should go into a second round of litigation over the recent developments. So, to me, this just underscores the importance of having your bill, sir, the baselines law. We should have had this yesterday, if I may. Because if we go to litigation again and China will point out again, you did not even have a baselines law. The baselines law, sir, just demarcates, from our point of view, our own rights. Now, I think the concern here is other countries may have a different view. Well, let them say so. Because the delimitation, if I understand it, is two countries will come together and delimit the overlap. So there's nothing wrong with us stating, the Filipino people stating in a Philippine law what our limits are. Let some other country say what is their limit, and then we sit down and then we negotiate.
How can we negotiate if we're afraid to craft our own delimitation, the boundaries? I think it's like the horse before the cart before the horse. So I am really at a loss for words as to the hesitancy of the DFA and the Task Force on West Philippine Sea. So dapat dito sa Secretary Anyo yung nandito eh. So parang ang gusto nyo, baka dalhin tayo dun sa mapunta tayo sa Article 38 ng Statute of the International Court of Justice. We're not yet there. Hindi tayo makaalis dito sa first base. Professor Beckham, you're listening intently. Can you hear us? Can you hear us?
Very clearly.
Yes, you're probably familiar with the maritime zone law of Singapore, Professor.
Well, we don't. We only have a puddle of water in Singapore, so we don't worry very much about a maritime zones law. We have no right to claim an economic zone or continental shelf in any direction, surrounded by our neighbors.
So
But
right now, yes. Go ahead. Go ahead.
If I had a general, again, I have not read your legislation. My apologies. I had very short notice of the meeting. But I would look to legislation of perhaps New Zealand or Australia, which we often look at as models because they're usually very good and they're usually in complete compliance with their international obligations. But to me, the most important issue for Philippines would be to look to the extent if you do issue maritime claims, you should take into account your existing boundary treaties, for example, with Indonesia, but also you should ensure that whatever legislation you pass is completely in conformity with the 2016 arbitral award. I think that would give you great legitimacy in your legislation. You should also think about the extended continental shelf claims made by Vietnam and Malaysia, and the extent to which the Philippines is going to make an extended continental shelf claim. These, to me, are the basic issues. I think the maritime legislation, if you look at some models around the world, you don't have to have the maps or conflicting claims when you pass the legislation. Any issue maps could be issued separately. Also, your terms of maritime claims could be issued separately. But if I were looking at the islands, for example, or let's say the geographic features in the Calayalan Island group, if I were advising the Philippines, I would advise you to take a position on each of those islands that is consistent with the 2016 arbitral award, in which they said certain of the features are high tide in their islands, others are low tide elevations. If your legislation were consistent with the award, it would give it much greater legitimacy if future disputes arise. That's a general comment. I'd be happy to put it in writing.
Thank you, Professor. I think that comment is part of our Section 10, wherein the arbitral award was cited, case number 2013-19, et cetera. So that's part of the proposed measure, Professor.
Okay, I'm very happy to hear that. But I think there's a question also, if you are going to claim an extended continental shelf out into the South China Sea, then I would ensure that you have provisions in your legislation on that.
Should be specified as well.
Well, all your maps don't have to be in your legislation. Your legislation could authorize the issuance of maps at a later date by the relevant authorities. To make a claim for an extended continental shelf, you must submit some information to the Commission on Limits of the Continental Shelf. So all your legislation would have to do is provide the basic framework for that, not the detail.
Correct. And that probably would also include the recently signed agreement concerning the high seas, wherein the Philippines is signatory, because everything is evolving.
That's right. So what you want in your basic legislation is the framework with authorizing the relevant authorities to do whatever they have to do with respect to extended continental shelves or high seas or your maritime boundary delimitation with your neighbors and so on. The other sensitive issue, I guess, from the point of view of your neighbors, is the issue of Saba. You're making
Issue
a
of?
claim.
I think Saba. I think it was raised by Senator Padilla during the first hearing. And what do you have in mind, Professor? Should that be cited?
Again, I think you might leave it to, I would pass your basic legislation first, so that your laws are in place, and I would leave it to subsequent authorities to issue where your baselines are under that law. And I guess the question I would have for the Philippines and Malaysia is, if Philippines, Malaysia, and Vietnam and Indonesia were to cooperate on the South China issues, they would be in a much stronger position vis-a-vis China. And therefore, I would try to find a way around the historic Sabah claim in a way that you're able to resolve your boundaries with Malaysia and work together. It may be very difficult politically, but that would be my advice as an outsider.
Another piece of legislation, perhaps.
Yes, I think you want a framework legislation on your basic maritime zone. That's not rocket science. That'd be quite easy to do. Where you want to leave the detail is if your claims overlap with neighbors, eventually your claims can be put out by regulations separately by the relevant authorities, and then you have to deal with negotiation. But for example, your water column boundary with Indonesia has been resolved, as far as I understand, by a bilateral treaty. You still haven't negotiated the seabed boundary with Indonesia. So you have to think about your subsequent boundary claims, if you do an extended continental shelf after your joint submission with Vietnam, you have to think about whether you are going to issue a separate claim as well and what the boundaries would be. But my general advice would be, in your main bill, focus on a bread and butter of make sure that it's consistent with UNCLOS. Subsequently, make sure any claims you make are consistent with the 2016 arbitral award, because that would enhance your legitimacy as problems arise with your neighbors.
What about some fruits, perhaps similar to what Palau did relative to scientific research, enabling them to benefit likewise? But this is part of UNCLOS.
Well, I think perhaps Stuart has raised the issue, or somebody, if you're in the loans legislation, you have in your economic zone, the coastal state has the right to regulate marine scientific research. You probably want legislation in there that sets out your rights and how procedures, again, can be put in the subsidiary legislation or rules and regulations as to how a foreign entity would apply to conduct research in your economic zone. That does not have to, all those details can be put in rules and regulations later, what we would call subsidiary legislation. You, I think, should focus on a framework for your main legislation.
Senator Gatchalian? Attorney Silva, Neil? Yes. Any reaction concerning this exchanges?
Thank you, Your Honor. May we note, Your Honor, that may I personally note that all of the points raised have been well taken. And I think, as noted by Professor Beckman, the task before us, which as noted by Justice Hardaleza, is really long overdue, is for us to already build that enabling legislation that would, in general terms, empower the executive to number one, map out what we have, and number two, negotiate with other countries, and number three, carry out other, as noted by Professor Beckman, subsidiary legislation. As we noted, for example, as noted by the DFA in the example of Indonesia, Indonesia came up with a very general, well, not really a general, but a rather long Law of the Sea Act, and thereafter, they promulgated their ASL laws through an executive issuance, a presidential issuance. So for us, Your Honors, however the wisdom of the committee might take it, the appropriate way for us would be therefore, number one, to already enact the general enabling law, and then number two, and then number two, and then it would bifurcate from there. The executive would come up with appropriate implementing rules to specify what are the laws and what are the norms that we would then incorporate by reference. Because we may note that the provision, Your Honor, of the bills all say that the Philippines will have the powers provided under UNCLOS and other relevant laws and treaties. And so the next step for the executive would then issue on general implementing rules and regulations that would look at what are those treaties under UNCLOS and under what agreements would then be written down into the IRR to specify what those norms would be, while the legislature may then proceed to further legislative reforms, including a maritime area or maritime area management law, which we currently do not have, but the foundation for which would be laid under this law. So as noted, Your Honors, this law is so very important to our national policy, not just on the external side of negotiating with our neighbors, especially given our many difficulties, but also internally, because it is also the basis for us to actually regulate. Because the regime given under UNCLOS will be the regime that will define what powers we can exercise. Number one, from the purpose of lawmaking or legislative jurisdiction, and number two, from the perspective of enforcement jurisdiction, because those are two different things, and those need to be clarified so that our own internal law enforcers can also do their tasks in accordance with law. So
The task is pass the law first.
yes, definitely, Your
But
Honor.
the problem of this committee now is NAMRIA is uncooperative, DFA is uncooperative, seemingly. And let the records reflect that they are indeed uncooperative. Ito, may note pa ang NAMRIA. I'll show this to Senator Gatchalian. So, mahirap yan ganyan. Pag gagawa pa lang tayo ng batas, ayaw na nilang mag-support. Di ba? Siguro next time, di na namin kayo imbitahin dito. Mahirapan lang kayo sa budget hearing nyo. I'll ask you to explain that. Si NAMRIA, meron daw nine-negotiate ngayon sa other countries, but that's not part of the West Philippine Sea. Ang layo na nun. Hindi ko alam kung bakit takot kayo. Pag yung namin ginagawa ang China, tatapang, pero dito sa committee hearing, hindi makapagsalita. Yung iba dito, binibigyan ko pa ng witness protection program. Yung kinulong kami noong Lunes, dalawa. So, it's really frustrating to see incremental steps being blocked along the way. DFA has something to say. Senator Gatchalian.
Mr. Chairman, I just want to share, express my support and express my support and share the same sentiment as what you have elaborated earlier. I think the overlapping is black and white, and it's quite it's all over the internet actually. If you go to Google and if you do if you're studious enough to do research, you'll see all the overlaps there. Not only here in Southeast Asia, but all over the world. I think academics have studied this very carefully. They've drawn maps that are as precise as official countries or official government agencies have drawn, and they're published in the internet for everyone to study. I think it's important to reflect all of those maps and overlaps in our discussion, Mr. Chairman. So I share the same sentiment as the chairman, and I would hope that the discussion will be as transparent as possible, because I don't also see any concern or any problem in showing the public the maps and also what is black and white, because it's published in the internet anyways. So, Mr. Chair, I share your sentiments, and I also want to appeal to our colleagues that hearings are meant to be as transparent as possible. Now, of course, we have a mechanism through an executive session, but if we can educate the public through open discussions, then that will be the best case. Thank you, Mr. Chairman.
Senator Gatchalian, DFA, you're raising your hand.
Thank you, Your Honor. First, I'd like to deeply apologize if the position of DFA was seen to be non-cooperative. I wish to assure the good senator and the committee that the DFA is fully cooperative. Just to maybe perhaps maybe the root of the potential misunderstanding is, yes, we believe we must have our own law first. Bahala na kayong ibang bansa, anong maisipin nila. So, if I may, perhaps we just wanted to flag that there will be concerns raised by the other states, but bahala yan. That's secondary. We fully support our law first. We're just flagging that, well, there will be some sensitivities, but we are not yet fully prepared to anticipate the positions once our law has passed. So please, sir, if there's any misunderstanding, I take the personal blame. But sir, please rest assured, we must push this act first. Then the second and third stages, as Attorney Neil and our good friends had stated, that's secondary. Definitely, sir. We want the horse before the cart. We're not trying to push the cart before horse. And again, any question, any issue, we are prepared to discuss in all transparency, sir. Thank you, sir.
Justice Ardelesa, anything to add?
I just want I just want to repeat, Mr. Senator, that I see frankly, I see no issue here of national security, because all you are doing is you want to have a law to state what our baselines law, to update it. So there's no, I can see no secret in this. The good senator is just asking us for what we should do. And as Professor Neil Silva said, we already know what we should do. So frankly, Mr. Senator, I see no reason for any executive session here. The baselines law, I apologize. I cannot comment yet on everything, but I will give you a written But it just means that the Philippines should state what is our baselines. So there's no secret about that. I cannot understand why some agency of government will say, why cannot you answer a straight question from the good senator? I'm speaking as a citizen, sir.
Justice Ardelesa, I still feel the same dismay concerning that, even given that belated sense of patriotism coming from the DFA. But leaving that as it is, I think we move on, but I reiterate the same, yung iba hindi ko na imbitahan dito sa susunod. And you will be explaining at the right forum what you have just did. Siguro paglabas ko sa media dyan, yun na rin sasabihin ko. Director Carandang, Yusek Domingo, flag ko kayo. Flag ko kayo. Solicitor General, you're about to raise your hand.
No, I was not about to raise my hand, Your Honor, but maybe just to move into a new episode of our discussion, you may wish to listen to the expression of full support by the Office of the Solicitor General.
Mate is also a member of the Office of the Solicitor General? State
Yes,
solicitor.
she is.
She was the one blocking this hearing a while ago.
No,
Her actuations.
I don't think.
You will no longer be part of the future hearings of this committee.
I will
assure
be-
you
I
that.
will
No,
be
no,
here.
no, Solicitor Jane, you will no longer form part of any working group. The same is true with the DA Karandang, unless you, no, I will not recognize you. I will not recognize you here. And if you want to step out, you can step out. The hearing of the Senate Maritime Committee and Admiralty Zones is hereby suspended. Professor